Greetings. I'm Chris Fabricant. I'm the Director of Strategic Litigation at the Innocence Project here in New York, here to talk to you about the role that unreliable forensic sciences has played in wrongful conviction and the role that the Innocence Project has played in exposing these really gross miscarriages of justice that have been endemic in the United States criminal legal system for many, many years. But we didn't know that until really the founding of the Innocence Project. So we're going to talk a little bit about the arc and the history of the use of unreliable forensic sciences in the United States, how they first got into court, and what we're doing to try to remove the use of junk science in criminal cases in the United States. One of the things that I wanted to be really clear about right when we begin is what I mean by junk science when I say this. It's a pejorative term. Forensic experts in particular take great offense to this term. So when I wrote my book, I wanted to be very clear about what the definition was. And what I mean by that, by junk science, is that junk science sounds like science. Like the experts and the literature uses the language of science, right? It sounds very sciencey, but it's really lacks an empirical basis. In other words, these hypotheses have not been tested through the scientific method. If there have been any experimentation, it's been very, very small numbers, the ends of 1 or 2 or 5 or 10, and then used to extrapolate out to an entire field. Primarily, junk science relies on training and experience, this kind of reflexive phrase that's embraced by courts in this country almost automatically, and you're going to defer to experts that have, a lot of training and experience. But if there's no empirical basis, there hasn't been scientific testing done to support the opinion that's based on training and experience. And what you have is just an opinion. And really, what evidence is there in these particular fields, particularly things like trace evidence, like fingerprints and tire treads and bite marks and kind of so-called ballistics or firearms and tool mark evidence? What evidence is there that this expert that maybe has 20 years in the field is any better or gets it right more often than an expert with, say, 5 years experience in the field, or even no experience in the field? And so much of the literature, particularly in trace evidence, shows that there's really no direct correlation between many years of experience and higher levels of accuracy. In fact, sometimes it's the opposite. And that experts that have years and years and years of training and experience tend to cut corners and to take shortcuts because they've seen this 1,000 times. They know how these stories play out and may not take the same level of care that somebody who's relatively new at in the field, and that will take that kind of precautions and be very extra careful. So as a threshold matter, junk science lacks an empirical basis grounded in scientific literature, and it's really just a science-sounding opinion. Evidence is eyeballed and declared a match, right? In science, almost all science outside of forensics, you're always measuring something, right? It's like this is true in social science, this is true in harder sciences, as a randomized controlled tests are done to, measure the effect against a control group, right? In regular science, any kind of an experiment, you're of course going to take measurements to demonstrate or falsify whatever hypotheses you're testing. In forensics, particularly trace evidence, we're talking about bite marks and fingerprints and hair microscopy and blood spatter and tire treads and footwear impression evidence and ballistics or firearms and tool marks. No measurements are actually taken, right? So these are just matches that are declared because somebody says so. It's somebody who has an opinion based on training and experience that these two things match. That's a subjective judgment, just eyeballing the evidence. And what we know about subjectivity is that with subjectivity brings bias. And bias is one of the most well understood aspects of human cognition. All of us inherently have cognitive bias. It's part of what it means to be human and to make decisions. And in other areas of science, there's great efforts to mitigate the influence of irrelevant biasing information to improperly influence the conclusions that a particular expert might have in a particular field. But this was never studied and really never even discussed in forensic sciences until the Brandon Mayfield case in 2004. And for those of you who aren't familiar with Brandon Mayfield, Brandon Mayfield was accused of the bombing of the Madrid commuter train in Spain in 2004. And the reason that he had been accused of this crime is because when they were going through the rubble of the train in the aftermath of that apparent terrorism attack, they found the blast caps. And the plastic bag that held the blast caps had some poor quality latent fingerprints on that. And the FBI uploaded these latent fingerprints into the AFIS system. So that's the automatic fingerprint identification system that's integrated in the United States. Has all kinds of fingerprints in it, people that have been in the military or work for the government or people who have been convicted of crimes, a very, very large database. So Brandon Mayfield's prints were matched or offered as a potential source of these latent fingerprints through the AFIS system. And the FBI individual examiners matched Brandon Mayfield's print to those blast caps because Brandon Mayfield had once served in the military, so his fingerprints were there. And when they looked into his background, they saw that he had recently married an Egyptian national. He had converted to Islam, and he had once represented a man that had been convicted of providing material aid to a terrorist organization. So those biological facts, or biography, I should say, of Brandon Mayfield were very persuasive. This was the type of profile of a person that the FBI assumed would have committed this type of an offense. And that information turned out to be much more relevant than the actual fingerprints himself. Brandon Mayfield was arrested and held incommunicado as a result of that fingerprint match and charged with this mass murder. 270 people were killed and thousands were injured. So Brandon Mayfield, though, insisted that it was not his fingerprint. Said he didn't even have a passport. He'd never left the country. So what the United States court did, which is a very unusual step, was appoint an independent expert and to reevaluate these fingerprints because the defense team was so insistent that they weren't their clients. So this independent expert, who is highly qualified, had many, many years of training and experience, and he concluded the same thing that the FBI concluded. This is Brandon Mayfield's print. Brandon Mayfield's defense team then hired their own expert, also very highly qualified, very highly trained expert, somebody that you would think was perhaps biased in favor of Brandon Mayfield, but he too came to the same conclusion as the other two experts and concluded that this is Brandon Mayfield's print. So it was not until the Spanish authorities, who never really thought that this was a great match and weren't entirely convinced, but the FBI latent fingerprint lab is the most widely respected in the world. It's supposed to be the best of the best. But it wasn't until the Spanish authorities identified an alternative suspect who was already wanted for other terrorist attacks that the FBI finally did, very, very rare, admit that they made a mistake. And they apologized, still rarer, and paid Brandon Mayfield $2 million. So what was thought of as the most reliable of these trace evidence, to have a high-profile false positive like this was a thunderclap across the forensic community. Nobody could really believe that this had happened, right? Because fingerprints aren't bite marks. Fingerprints, and I'm not here to tell you that fingerprints are junk science, but you can take an otherwise fairly reliable field and make it pretty junky if you have low-quality evidence and the influence of bias. And that's exactly what happened in the Mayfield case. And bias is not really being understood and rejected by many forensic experts who believe that they can just will away this fundamental product of human decision-making that none of us can will away. Many experts reject this notion, say, I'm just looking in the microscope, I'm making that decision, and I can't be influenced by any of these other factors that lay people are influenced by. A cognitive neuroscientist named Dr. E.T.L. Dror decided to do an experiment in the aftermath of this high-profile misidentification. And what he did is that he took a group of latent fingerprint experts and asked them to do some casework. But what was clever is that he didn't tell these experts that they had already come to conclusions on these latent fingerprint and exemplar cases. In other words, this was their own prior casework. They didn't know that. And the only thing that he changed was the irrelevant contextual information that was included in the case files. In other words, the information like the suspect confessed, or there's an eyewitness, or there are things that would point an expert one way or another. Three-fifths of these experts changed their original opinion from identification to an exclusion. And the other 2/5 came to inconclusive decisions. So that is the power of totally irrelevant information, totally irrelevant, that changed from identification to an exclusion, right? So this is the power of contextual information on our decision making. And still today, there's almost no effort to eliminate the biasing information from influencing these decisions. And we see this in wrongful conviction again and again and again and again. And there's other types of bias that we also all share. And this is racial bias. And if you've studied the American criminal legal system, you can see that it has grossly disproportionately impacted poor people and disproportionately Black and brown people in this country. And, when you're looking at it through the lens of forensics, Dr. Dror did another experiment recently in the last couple of years. I'll be very reductive and simplistic about the results, but what they tended to show was that when babies that have the same set of diagnoses, the same injuries, are taken to the hospital, the white baby's parents with the same injuries as the Black baby's parents, the white baby's caretakers tend to go home, and the Black baby's caretakers tend to get charged with homicides. And this is because another subjective judgment is being made. This is an intentional injury, or is this an accident, right? Is this like good parents that would never hurt their children? Or are these bad parents that were abusing their children? That's a subjective decision, right? Because it's the exact same injuries. So this is all to say what I mean by junk science. Is that it's subjective. There are no measurements taken. It's grounded in training and experience. There's no real scientific literature to support it. And no efforts are made to shield the examiners from biasing information. What you have typically in the literature, so to speak, are case studies. And case studies are not scientific experiments. Case studies are stories. Case studies are a fingerprint expert, bite mark expert, or somebody like this describes how they solved a particular crime. I use this technique and I use this technique, and then, I made the match and the defendant was convicted and that worked for us, and you should try this too, right? That's not a scientific experiment. That's a story, right? But it's often published in the scientific literature, like the Journal of Forensic Sciences and the countless other journals, to suggest that there was some scientific support for this when there really wasn't. There was just one study. So all to say, that is my definition of junk science. I think it stands up to scrutiny. And then, when I started at the Innocence Project in 2012, and what my role was there is to start the Strategic Litigation Department. And what our department was going to does now, is challenge and litigate against the leading contributing factors of wrongful conviction. And when Barry Scheck and Peter Neufeld and I, those are the co-founders of the Innocence Project, sat down to talk about what kind of forensic techniques that we were going to be challenging in court, we settled on bite mark evidence as the worst offender, as that had contributed to the most wrongful convictions, that had the least amount of scientific support, and that was still being used here today. My job was to, amongst many other jobs, was to know everything that I could possibly know about bite mark evidence, or in other words, to understand it and to understand how we could prevent its use in the future. And what's unique about bite mark evidence is that you can really go back to the actual source and to the first case, to the first experts in the United States, and take a look at how did this happen? How did junk science get into court? How does it stay in court, and why? Really, what are the forces? What do you need to accomplish to make this happen if you're interested in getting junk science into court? And one thing that I'll give you a couple of examples of why bite mark evidence is junk science. And then for those of you who want to debate that, you can email me offline. But two things that I'll just point out as a really basic level understanding is that one is, and I never saw this cross-examination in the dozens and dozens of cases that I've worked on, in the 8 exonerations that I've been part of in bite mark evidence, a cross-examination that discusses the fundamental problem with interpreting injuries on skin, particularly trying to match something. and that this is true with live victims, and it's true with deceased people or cadavers, is that bite mark experts come along at some point in time, right? So either days or hours or weeks after a homicide. And we know that about bodies and about skin is that a decomposing human being, the skin changes constantly. First it swells, then it shrinks, then the skin sloughs off. And so the skin changes day to day, hour to hour, week to week, right? So the expert comes along, takes a picture at some moment in time, and then gets a dentition, a mold of the suspect's dentition, and matches these two things together. But it might not match the day before, and it might not match the next day, right? Because skin is constantly changing in unpredictable ways, and nobody was there when the injury was inflicted. So it's possible to make an interpretation like that. The other thing, and I encourage you to look at Dr. Ian Priddy and Dr. Adam Freeman's research called the construct validity test. And what that shows is that bite marks cannot be diagnosed reliably as so-called human bite marks. They are the top experts in the field, that all board certified, all highly credentialed, could not agree on the simple threshold issue as to what a bite mark is on 100 different cases, different samples that they showed each expert, and they were like all over the place. If you don't have inter-rater reliability, in other words, two experts with similar amounts of experience looking at the same data don't come to similar conclusions, you don't have any reliability when you can never know ground truth, like we can't know in these cases, right? So this is not a battle of the experts. This is just an unreliable field where you say it's a bite mark, I say it's not. There's no way for us to test it. That's unreliable. So that's bite marks. I know that it's being used in India. I see the stories. It gives me great fear because a very high-profile gang rape of a woman, bite mark evidence was used successfully. And I'm going to talk to you now about a similar type of situation here in the United States that led to the takeoff of this junk science. And now today, at least 40 known wrongful convictions and indictments, right, based on bite mark evidence. And this is a relatively, obscure field. It's not used that often. So when it is used, very, very unreliable. So how did it get into court? How did we get here? And so I went back to the first documents, and I could find that in the 1970s, there was a lot going on in the legal system in the United States. You couldn't really, when you were a kid in the 1940s, you couldn't want to grow up to be a forensic scientist, right? That was not really a profession. That wasn't, the field had not been professionalized like that. In the post-World War II era and the opening of the FBI crime lab, the field became much more professionalized, right? And then the forensic pathologists organized with the first credentialing organization to offer board certification to forensic pathologists. At the same time, the legal system was growing exponentially, and more forensic sciences were being used in criminal law. And on the civil side, there's a whole new cottage industry of personal injury litigation, product liability, mass torts, toxic tort litigation, right? So exponentially growing the civil side of our legal system, and a lot of new scientific evidence was being used in that system and the civil system as well. Entire industries sprung up in the United States to support litigation. Experts were working in this field were no longer even working in the field. We're just working as expert witnesses. That was a full-time profession for many people, just to support litigation. On the criminal side, we had the buildup of mass incarceration in the United States with the drug war and the so-called war on crime, or tough on crime policies and this kind of thing, that led to 2.3 million people in this country locked up for various reasons. By far, the highest incarceration rate in the world. So this was what was going on, and then you could see in popular culture, which plays a huge role in the the continued kind of depiction of forensic sciences as infallible. And so a show like Quincy, which is a very popular show in the United States about a crime-fighting forensic pathologist who was out solving crimes and this kind of thing. And that was kind of viewed as the role of forensic experts, these brilliant crime fighters who can solve, these complex, mysteries, through their science, right? And sometimes that could happen, but, usually not. People were being lionized as these, brilliant experts that were crime solvers. And the forensic dentists were part of this community, but not really. They were very marginalized, right? Because they were already working in the field. But what they were doing had nothing to do with bite marks, right? What they were doing is they were working with the forensic pathologist in the medical examiner's office, identifying dead bodies, right? And so we've all heard these stories about bodies burned beyond recognition, and that they could only be identified through their dental records, right? And so that's a pretty straightforward process for forensic dentists to do. It's not very sexy, and it wasn't like getting them into court. That wasn't making them part of investigation teams. They weren't really kind of doing the more fun and more interesting aspects of forensic science. And so they started openly lobbying for the use of bite mark evidence. And like I said earlier, it has good curbside appeal, right? They were like seeing these injuries in the medical examiner's office on bodies that say, hey, that looks like a bite mark. I bet if I had the teeth, could match those up to the bite mark, we'd have our bad guy, and we would be part of the investigation team, and we'd have a slice of the forensic pie that, we feel like we earned. So that was just the idea, right? So there's no experiment, there's no science, or just like this kind of idea that this could be done. There had been a case in the 1950s where cheese, been bitten into, and so there was some notion out there, but on human skin, which we've already talked about, it's an entirely different proposition. So what these original 12 founding fathers, they started calling themselves, these dentists started meeting, and they decided, and there was an article by Lowell Levine that I found in the ABFO archives, the American Board of Forensic Odontology, which didn't exist yet. He wrote an article, and this is many articles that were similar around this, that was openly advocating for the use of bite mark evidence and what they needed to become an established field. And the first thing that Lowell Levine and others understood was that they needed credentials. Credentials are the lifeblood of forensic experts. All these experts have like a lab coat and an alphabet after their name to suggest that there's a lot of very powerful board certifying credentials here. And they knew they needed that. So they invented the American Board of Forensic Odontology. Still today, the largest, most significant forensic odontology, board certifying entity in the world. All invented, totally made up. They just gave themselves board certification. They didn't have to prove that bite marks was valid. They didn't have to prove that they could match anybody to a bite mark, that they could identify a bite mark as such. They just had to memorize the dogma, the collection of the data, right? So in most junk sciences, there's very, very strong emphasis on how precise the data must be in collection, right? And very fancy photography, very specific dental molds, and very exact, and taking measurements that don't mean anything. They'll actually just take some measurements. Oh, this injury looks like this, it's so many millimeters, but that doesn't mean that the teeth are going to be so many millimeters. It's just a measurement. So there was no testing done or anything like that. They just gave themselves board credentials. And so then they became ABFO board certified diplomates, they called themselves. And then they went to the American Academy of Forensic Sciences, the largest forensic organization in the world. It's a very important baseline credential for most forensic experts in this country to be a member of the AAFS. I always enjoy the cross-examinations when I have these experts because I too am a member of the AAFS. You just have to go and give talks, right? So, but what they needed is that their own section, right? They had been kind of hanging out with the forensic pathologists in the biology section for a long time, but to have credibility and like an entry into the field, they needed the odontology section. So they basically stormed the castle with their Trojan horse of identifying dead bodies, and the forensic pathologists helped sponsor them. And suddenly they had their own section within the AFS, the odontology section, still one of the largest in the organization today. It was a very, very important first credential. And then they started taking titles like the chief forensic odontologist for the city of New York, right? And that title exists today. There's a dentist that has that title. And so think about, what we have here is an entirely invented field, total junk science. Nothing has ever been used in court. No real experiments have ever been done. But you look at going into finding the first case, you could already say that I'm a board certified forensic dentist and a diplomat of the American Board of Forensic Odontology. I'm chair of the odontology section of the American Academy of Forensic Sciences. I'm the chief forensic odontologist for the city of New York. That is a very impressive mouthful of credentials for something that doesn't exist. So what was interesting, though, is that 4 of these original 12 founding fathers were lawyers. They had JDs. And lawyers understand the power of precedent. And they knew that they needed a good first case, right? And so the first case that they waited for their test case came in 1974 in Los Angeles, the Walter Marks murder trial. And Walter Marks apparently murdered his landlord, but there was very no direct evidence. There was a lot of circumstantial evidence pointing towards his guilt, but there wasn't anything that they could do. And I'm sure that you folks will be able to handle a little bit of a gross description, but what happened is during the course of this homicide, very vicious homicide, the victim had her nose bitten off, essentially. And the injury that leaves is in cartilage. It's not in skin. It's different than some of the properties of skin that we discussed. So this was an ideal first case. And so they went for it. And 3 dentists came. They were all qualified as bite mark experts for the first time. Walter Marks was convicted and never heard from again. And bite marks had their first toehold in court. And what was really interesting and important about the case, not just for bite marks, but for all these trace evidence, was that the judge acknowledged out loud that there had been no scientific experiments to support this, right? So it wasn't, and he was basically said that there was no science, but that this was so simple, it was such like basic matching testimony, and that the visualizations spoke for themselves, is that the jurors themselves could see whether or not this matched or not. They weren't going to be hoodwinked or fooled by some black box technology or something that they can't understand. They'll be able to see for themselves. So therefore, they're not even going to be subjected to the type of scrutiny that American courts are supposed to apply in scientific evidence cases, right? The so-called Fry test, which means that it has to be generally accepted in the relevant scientific community, right? So in other words, if scientists accept this, the courts will accept it. But he said, no, we don't even need to do that because this is so simple. As long as the experts are qualified, we're going to let them testify. And they'd already established all their qualifications. They made them up. So they gets into court. That first case becomes a germinal case. And I wrote a law review article, Cases of First Impression Across the United States, cited back to the Marks case. And it became just through judicial fiat. They started calling it science. And it became scientific evidence. And all these cases around the country pointed back to Marks. And so what you had right at the beginning was an invented field, invented credentials, you get in the case law, and then all these courts start pointing back to the original case, and it becomes established field. But still is relatively obscure still, right? And then what happened is kind of the ultimate case study. Kind of something similar that happened in India is what we had in the United States is a Ted Bundy case. And for those of you who are not familiar with Ted Bundy, he's the most notorious serial killer in United States history. And in the late 70s, he was on an incredible murder spree that had started on the West Coast and finally ended with his arrest in the Florida Panhandle on the East Coast of the United States many years later. And what was really, the Ted Bundy case is really the ultimate case study, right? Because nobody thinks that Ted Bundy was innocent, right? And so it's a great case to talk about. Everybody's familiar with it, but few people are familiar today that it was actually a bite mark case. And what happened is that the sheriff who had first arrested Ted Bundy, it was a fluky arrest. He was just driving a stolen vehicle. It was right after the so-called Chi Omega murders, this American sorority in Florida State University, a southern town and a southern university where a lot of white girls were killed in their own beds, right? And that's a very high-profile crime. So this was the ultimate one of these because this Ted Bundy character, nobody could believe that he could be a serial killer because he seemed so normal. He listened to public radio. How could a killer listen to public radio? These types of things. And so they became a media sensation. The sheriff at the time had only been in office for 6 months. He was only 32 years old. He had almost no law enforcement background. His main credential was that he'd been teaching forensic techniques at the local community college. So he's under a massive amounts of national and some international pressure to bring the charges for the so-called Chi Omega murders. And so after his arrest, he's giving a press conference. He says during this press conference, he's asked, when are you going to bring the indictment for the so-called Chi Omega murders? And he's like, well, we think it was him. He was in the area. It fits his, MO or modus operandi. But the problem is we don't have any physical evidence. There was one eyewitness who saw a man fleeing the sorority right after the murders, but that witness, under hypnosis, had identified an employee of the Chi Omega house as the person that she'd seen. I'll pause here to note that hypnosis is also junk science. Memories never get better. Never. That's not the way memory works. They can never be improved through hypnosis. They can only be corrupted. And you see this in wrongful convictions all the time. We're going to hypnotize this witness and therefore, explore into their brain and, get a snapshot of a crime scene. That's nonsense. So they didn't have any physical evidence. And then 4 months go by. The media pressure becomes insane, right? Every day, another story, right? And so Sheriff Katarsis realizes he's got to do something. And because he'd been teaching these techniques, he's aware of the latest developments in forensic sciences. And he's aware that one of the founding fathers of the field, Dick Souviron, is right there in Miami. And so he gets Dick Souviron up there. And if you Google Ted Bundy bite mark or that kind of thing, it's all over the internet. You'll see Dick Souviron's bare fingers in Ted Bundy's mouth. It was videotaped. There was live taking of his dentition. And he comes through with a match. 2 other bite mark experts testify at this trial. And it was the first nationally televised criminal trial in American history. And 80% of the country, according to polling at the time, wanted Ted Bundy executed. And the case rose and fell on the dentist's testimony. So he gets convicted. As I say, broken clocks are right twice a day. Could have been a bite mark, may not have been a bite mark, could have been Bundy. Who knows, right? Probably he was guilty. I'm not here to tell you he was innocent, but it wasn't the bite marks that proved it. And so, but they became huge celebrities. Every one of those dentists went on to convict innocent people, including Dick Souviron and including Lola Levine after that, because they had great belief in their own abilities after the end of that trial. So that's how credentials, case law, celebrity. I devoted a chapter in my book to discussing this because bite mark evidence is the poster child for unreliable evidence. And what happened with it is you can use the same kind of thing you can see in all kinds of different forensic techniques that essentially the same path forward into getting into court. And then once it's in court, judges, as we see with the original bite mark case, they're not concerned about the science. They're concerned about case law. And if the case law supports it, it's going to come in. Case law is static. Science is always moving forward. There's a fundamental tension. Think about what else was going on in the 80s and the 90s is that forensic sciences were being exposed. And they were exposed through the advent of forensic DNA technology and the opening of the Innocence Project. And one of the really important, maybe the most important decision when the Innocence Project first opened its doors was the intake criteria. And that it was decided that we're going to make no subjective judgments about the guilt or innocence of people that were applying for our help. The only criteria was going to be, can we find biological evidence and test it? And would that prove innocence? That's it. So we took cases with 6 eyewitnesses. We took cases, all kinds of forensic sciences pointing to our client scale. We took cases with detailed confession, took them all, and tested it against the truth-telling serum of DNA, right? And what we saw was astonishing in that over 50% of all known DNA exonerations are attributable, at least in part, to the misuse of forensic sciences. 50%. This led to, years later, a National Academy of Sciences report. And what you could see with the National Academy, so the National Academy of Sciences in the United States is the most prestigious scientific organization. And it's one of the most prestigious in the world. It's a lifetime achievement for anybody to be named a member of the NAS. And no mainstream scientist has ever been asked to look under the hood of the claims that forensic experts were making in court and were being accepted in court for the last century. No mainstream sciences had ever been looked at. It was all developed by law enforcement and forensic experts and kind of an aside from the mainstream scientific community. It wasn't developed in laboratories like DNA. which is a fundamental problem because like the culture of scientific experiment in mainstream science is about, your data being subjected to peer review and scrutiny, sometimes harsh scrutiny, right? Because that's how knowledge is developed to move forward. That had never happened in forensics. After all the wrongful convictions, the United States Congress engaged the NAS and paid for a study to look under the hood of 13 of the most commonly used forensic techniques in the United States and really all over the world. I recommend it to all of you. It's easy to read, and and there detailed reports on all the techniques. But one of the really main takeaways was around individualization. And what I mean by that is that you see this in bite marks and fingerprints and ballistics and tire treads and all these trace evidence that we've been talking about is saying that that gun, to exclusion of every other gun manufactured in the history of time, it fired that bullet, and only that gun could have done that, right? So that's individualization. You see that in all these other fields too. And what the NAS said was that only DNA analysis, nuclear DNA, not mixtures, nuclear DNA analysis is capable of identifying the source of crime scene evidence, right? Only DNA. So all these techniques that have been making these claims, there's no support for that in the literature, zero. And that should have been a game changer, in the United States. We know it's leading to wrongful convictions. We know that the scientific community has rejected these claims entirely. So if you look back, we talked a little bit about what was going on with the civil litigation. And all these corporations were getting their pantsuit off during the same time. And a lot of people were being wrongfully convicted at the same time. And a lot of the so-called science that was used against corporate America was junk. And a lot of the science that was being used to convict our clients was junk. Corporate America, though, had a plan. And their plan was called tort reform, right? And so tort reform was an effort to limit damages, but also they wanted a new evidentiary regime. And they wanted courts to stop admitting junk science against their clients. And so what they did is they teed up a case called Daubert. So they teed up this case and they wanted to stop deferring to the relevant scientific community and do some independent judgments about the validity of the technique, because courts had uniformly defined the relevant scientific community as the same experts whose livelihoods depended on the continued acceptance of this field, right? So if you ask those folks if their science is generally accepted, of course, they're going to say yes. In bite marks, our courts define these dentists who invented the whole thing as the scientific community, right? So they got this case to the Supreme Court and they won. They got a whole new regime, right? So that the courts are supposed to think about things like error rates and testability and peer review and the maintenance of standards and general acceptance as a proxy for scientific reliability, right? And the reliability is going to be linchpin. Courts, you have to think about this before you introduce this evidence. Criminal law, of course, I use this term poor people science, and I'll explain that term, why I use that term in my book. But criminal law was barely mentioned. It came up once in oral argument and not at all in the briefing. What was called junk science was done by, there was a book that preceded mine that was called Galileo's Revenge that was written by Peter Huber. And that was the first coining of the term junk science in American popular culture. It started this whole off, and he was using it to talk about civil litigation. But of course, it was going on in criminal litigation too. And that book was cited by the courts all the way up the chain to the Supreme Court and was very, very influential. And so Peter Neufeld did a study in the aftermath of Daubert that showed, despite all the wrongful convictions, despite the NAS report, despite everything that we know about forensics, nothing had changed in the criminal legal system. Nothing. I did a follow-up study with Professor Brandon Garrett from Duke Law School in 2018 that included the President's Council of Advisors of Science and Technology 2016 report, the follow-up from the 2009 NAS report, came to very similar conclusions, and saw that nothing had changed despite everything that we know about the use of junk science in the criminal legal system. And defense had never been successful at challenging forensic techniques that were known to lead to wrongful conviction. So the only conclusion that can be drawn from these data are that we care much more about the reliability of the science when money is at issue in this country than when the lives and liberty of poor people in this country are at issue. And that's why I use the term poor people science in this country to describe the science that is used in criminal courts, because we don't care about the quality of that evidence. And so really my purpose is to make us care. It's why I wrote the book, and it's why I do the litigation that I do. It's not just to care, it's to try to rescue people who have been convicted on this junk science and also prevent the continued use of this. So when I see developing systems that are kind of adopting, our same problematic techniques, in India, I get all of these news alerts that talk about, the claimed abilities of forensic experts. And I have people on LinkedIn yelling at me from India saying that this is good science and we've solved all these crimes, and that I'm an idiot and I don't know what I'm talking about and everything. It gets very frustrating because I've been there. I've walked people out of death row that were put there by bite mark evidence. I have 3 clients on death row right now today that are put there through bite mark evidence, and prosecutors are still defending those convictions. I'll close with this. Be very, very careful about what you call science and what you allow into your legal system. Listen to the mainstream disinterested scientists. Get outside opinions about people who don't care about the litigation, don't care about the adversarial system, don't care about the case. What they care about is good science. If you follow the scientists, you're going to be in much better shape. Thank you for having me.